ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we'll be hearing today are Justice Gabrielle Wolohojian and Justice Sookyung Shin. The first 3 matters are criminal matters. After we hear the argument in the 3rd case on the list, we will take a very brief recess and resume with the civil portion of our hearing list. The first case on our list for hearing this morning is case number 2020 P331, the Commonwealth versus EDMANUEL ANDRICKSON. Attorney Oos, you may begin.
Good morning, Justice Green. Good morning. May it please the court. My name is Attorney Adam Oos. It is my privilege to represent EDMANUEL ANDRICKSON. This court must reverse Mr. Andrickson's conviction for reckless endangerment of a child. The evidence is insufficient as a matter of law. Under Chapter 265.13L, wanton or reckless conduct must create a substantial risk of serious bodily injury. That is, the evidence in this case is insufficient to establish that such risk existed here. The standard, as we all know, is that the Commonwealth, this court must review this case in the light most favorable to the Commonwealth. So let's look at what the evidence is in most favorable to the Commonwealth. The witness in this case, Ava Saldier, says she witnessed Mr. Andrickson punch Mary Minion in the face while she was holding her child. She was unable to explain how hard he hit her, if at all. He was unable to explain how hard he hit her.
But may I ask you, she did use the word punch.
She did use the word punch, yes.
And that has a certain meaning and certain reasonable inferences that can be drawn from that meaning, from the use of that word, I would say. So she didn't say that the defendant slapped the victim in the face. I think if she had, I would infer that the defendant's hand was open. When the witness uses the word punched, I can't help but infer that that was done with a closed fist. Don't you think that's fair?
I think it's very, the short answer, Your Honor, I think it's fair to say that it was she described it as being done with a closed fist. I think there was some question at trial as to her vantage point and what she could or could not see.
Oh, okay, but at this point, we're taking it all in the light most favorable to the Commonwealth. So and I also think that a fair inference from the word punch is, again, it's not a tap. The word itself carries with it a certain meaning of force. In other words, certainly someone could say that a person punched another person with force, but just saying that a person punched another person, I think for most people would lead to the inference that force was involved. Without attaching a degree to it, conceitedly without attaching a degree to it, but that there was force involved. Would you agree with that?
Not on this record, Your Honor, and I'll tell you why. Because quite specifically, if you give me a minute, I can get the record reference here, but I think it's page 101. Here it is. Transcript volume 4, page 101, 102, asked directly, was the punch with force? And Ava Saldier said, I assumed it was, but I don't know how strong it was. And I'm paraphrasing. She said, I don't know how strong it was. So while there's an inference that it was with a closed hand, we still are dealing with a sort of quantum of force here.
Yeah, of course. But I think you would have to agree that the witness's testimony permits the conclusion that the punch was with force, although the witness couldn't quantify the degree of force.
Well, I think the problem here, Your Honor, is that we cannot rest. Again, there's 2 issues. One, there's the level of force here, and she can certainly say it was a punch, but we have to look at what evidence there was that was with sufficient force to have created the risk of the requisite harm here. The other issue is that
Do you think that a jury could reasonably infer that a person who's punched in the face may well drop something that's in their hands?
Not on this record, Your Honor, because what we need is some other evidence that that was likely to happen. We're looking at the.
What about common knowledge? If I go up and punch someone in the face, or if someone punches me in the face, why wouldn't it be just a reasonable inference based on ordinary human experience that I might drop that, the fact of being punched in the face, just someone walking right up to me and punching me in the face, no preamble to that, just run up the stairs, punch me in the face, that I might not, whether from surprise or the force of it or just the fact of it, drop something that I'm holding in my hands. Why would that not be a reasonable inference based on common experience?
Because of the facts of this record, Your Honor. Now, I mean, you're talking about the Lopez case where the alleged victim in that case was walking up some stairs carrying a bag of, I think it was delivery food, Chinese food. And the assailant in that case was coming down the stairs and punched him with, I think the case said, with sufficient force to knock him backward. And the quantum of force still came in. That was not a reckless endangerment case, Your Honor, but the quantum of force still became a question. The other issue here is that we have no, first of all, the allegation in this is Ava Soler says that if Mr. Andrickson had missed, he would have hit the baby. There was never an allegation that she was likely to drop Genesis. There was never any facts that indicated that she might drop Genesis. And even if that were the case,
why isn't that a reasonable inference that that's a risk?
Because, Your Honor, I'm relying on the facts of this case. I'm looking at what we have, what the jury had, what facts the jury had on the record.
I think what I hear you saying is that what you're calling the facts is the direct evidence. But you know, when we test the sufficiency, we're not just looking at the direct evidence, we're also looking at the reasonable inferences from that direct evidence, the circumstantial evidence as well.
We don't need to see actual consequences. The question is whether there was a risk of harm or injury and dropping the child, which could be the product of startling the mother as she was holding the child, or it could be the result of flinching and trying to shield herself from the blow, a natural instinctive response to an arriving fist. It could be an indirect consequence of receiving the blow and being momentarily disabled. Or there's the other risk that the percipient witness, the neighbor, identified as the risk that the punch would be misdirected or misaimed and directly strike the child. All of those are reasonably identifiable risks and inferences in the hands of a pool of jurors.
To your point, Your Honor, if I may respond. So certainly there's the direct evidence of what was likely. What did we see from Mary? Did she stumble? Did she shy away? And we don't have any of that. She stood, according to Ava, she stood there. So there was, or she didn't say Mary stumbled. But even if that were a reasonable inference, and I take your point, Your Honors, that especially with the Lopez case, a punch could conceivably cause someone to drop whatever it is they are holding or carrying. The requisite injury, however, we need to know, obviously we don't, an injury need not be shown for reckless endangerment, but the facts of what would happen to the child, how that child is dropped, how far they would fall, if at all.
Was the evidence that the mother was standing?
I'm sorry?
The evidence is that the mother was standing, right?
Yeah, the evidence is that the mother was standing, and when I think I page
the evidence was that the mother was standing at the top of a flight of stairs.
There were two statements that Ava Soler made. Page 487, she said that she was standing at the top of the stairs, or she was standing on stairs. But then on page 101, when specifically asked, she said Mary was on the porch, and then asked again to clarify, and she said, yes, Mary was on the porch. So, you know, we don't know what that porch was made out of, you know, and that's why I guess.
Oh, wait, is it a fair inference it was not made out of styrofoam?
I think it's also a fair inference that it wasn't made out of concrete, Your Honor.
Let's for the moment assume that it was made out of wood. Okay. You know, I happen to have the great good fortune of having my newborn granddaughter living in an apartment one floor below me, and find myself on very frequent occasions, including last evening, walking around my apartment holding her. Now, I'm taller probably than the mother in this case, but I will tell you that I do not have any desire to drop that child onto my hardwood floor. Risk of for fear of serious injury to the child.
I'd like to be able to move on to the restraining order issue, but I will address it this way, Your Honor. Not wanting to. This is the reason I included the Rosa case, to show that a missed punch or a drop or some degree of force is not facial evidence that the child is going to suffer the requisite harm. And the Rosa case is a little different, but it shows that in that case, there was a father who, I think it was in a CVS, kicked his daughter in the chest. The child fell down and cried. And the father was, according to that record, 3 pounds. So the simple fact
that was a parental discipline case.
Yes. So the simple fact, I included it because the simple fact of some kind of striking on a child is not necessarily going to give rise to the requisite injury in this case. And our argument is
you're not arguing that this punch was a form of parental discipline.
No, not at all. No, we are. I'll leave it there. No, that's not the allegation was that, well, yes, that Ava saw him punch her. That's the allegation.
You suggested that you wanted to offer some argument about the impeachment evidence.
That's correct. Yes. So it is our argument that the references to the 2018 restraining order, specifically the content of that restraining order, should not have been admitted in the way that it was. We recognize, and you know, I have to concede that the law allows for a wide swath of reasons to put in prior events, prior acts, prior statements.
And in addition to the wide array of reasons, we assess the judge's decision in a particular instance under the standard of abuse of discretion, right?
Yes, yeah, it's abuse of discretion in this case, because it is preserved error, and I think the Commonwealth agrees with me on that it would be a prejudicial error in this case. Our argument essentially is that this was admitted not for any probative purpose in this case. It doesn't actually qualify as a prior inconsistent statement. It doesn't speak to, it is not necessary to speak to the nature of their relationship in this case. It was ample evidence of the nature of the relationship, even from Mary, who said, we argued all the time. So this is event.
Is your argument that the contents of the restraining order shouldn't have been admitted? Or I thought it was that the contents of the affidavit in support of the application for the restraining order shouldn't have been admitted?
Our
I'm a little confused.
Essentially, it's that references to that restraining order and its contents should not have been.
The restraining order or the affidavit? Because the contents of the restraining order are just, you know, stay away, et cetera, et cetera.
So we're saying the fact of the restraining order, at least according to the motion in limine in this case, the references to the fact of the restraining order should have been introduced, but at the very least, the content of her allegations, the content of that affidavit should not
Her
be.
affidavit. Oh, that's what I thought it was. Okay.
Right. Yeah, because, well, trial counsel argued that it became propensity evidence. I believe in my brief, we argued to some degree that it is propensity evidence. And it served no probative purpose in this case. And as a result, it was the prejudicial effect overwhelmed the probative value of this case. I see I have about 25 seconds left. If there are any further questions, Your Honor. Thank you. I'll stand on my brief.
Thank you. For the Commonwealth?
Morning, Catherine Sullivan for the Commonwealth this morning. I'll dive right in here and provide what I think is some helpful support for the Commonwealth's position that there was more than sufficient evidence that the defendant recklessly endangered his one-year-old child. Unfortunately, the exhibits that were admitted at trial are not included in my brief. I tend to include them if I think they're relevant, and I think because I did this brief during COVID times and didn't have easy access to the court exhibits themselves, they weren't included, but I will definitely put in a motion to transfer those exhibits to the court this afternoon. Several exhibits were admitted that demonstrated.
Copies of the exhibits?
I'm sorry?
You have copies of the exhibits?
I do have copies of the exhibits.
It might be easier that rather than asking the trial courts to transmit it to us, to file your motion seeking leave to file copies with us.
I only had the copies I have, and this is why I think I didn't include them in the brief, was that don't have the exhibit marks on them. And I'm usually reluctant to send copies of the prosecutor's exhibits without those to the court. So in the event that I don't have copies with the trial sticker on them, it might be easier for this court to just request that the court send to them, but whatever you want me to do, I need to get the exhibits to you to help you with this.
You know, it may be possible for the two of you to enter into a stipulation, and the exhibit sticker is less significant to us so long as you can offer us the appropriate references to what is what for the purpose of our review of the visual content.
Okay, so
I think that our experience during the pandemic has been that with short staff and many other competing priorities, it can be cumbersome to have the physical artifact transmitted, even from next door at Suffolk, and counsel can again stipulate that the visual representations that they submit are an adequate substitute for our purposes.
okay, that's helpful, thank you, because usually I do include them in the brief if they're supportive of my argument, which they are in this case. So with respect to Justice Green's question about the nature of the stairs and where the victim was standing, it's apparent from exhibits 2 and 3 that were entered into evidence that the victim was standing on the porch of the house, which was at the top, which was a small area, maybe 5 by 6 feet, and was at the top of 5 or 6 wooden stairs with concrete at the base of them. And the testimony was unequivocal that she was standing on top of that porch when the defendant ran back after having left, ran back, and then punched her in the face. So that's one thing that may help put the incident in context. Another exhibit that would help would be the exhibits 4 and 5, which were pictures of the victim that showed redness around her neck and scratches to her left ear. And those are exhibits 4 and 5. Those were admitted. Those aren't in either of our briefs. And also exhibit 6, which
what evidence would have permitted the inference that those were caused by the punch to the face?
Well, there was a scratch on her left ear and there was bruising on the left side of her neck. So reasonably, those could have resulted from the punch.
The scratch would be an unusual consequence of a closed fist punch. And not to personalize this too much, but again, when I carry my granddaughter, it can be a scratchy experience.
Right. And the scratches, and the testimony was unequivocal that the punch was to the left side of her face. And there was a scratch on her earlobe, I think, and one maybe on her chin, and then some marks underneath her chin. Other than to the left side of her base, there wasn't a more accurate description of where the punch itself landed. So we have that. We also have the EMT notes from when the victim was treated, when the ambulance arrived on scene, and that was admitted as Exhibit 6. And within those notes, the victim herself says that her head felt funny. And I think from that, we can, a reasonable person could infer that she was punched in the head and likely felt funny for that reason.
The need for medical attention following the blow to the head is at least some evidence of the degree of force, it seems to me.
Correct. So all those things were before the jury and supported the inference that the punch was done with some force. Unfortunately, I think in a reckless endangerment case, we like to rely on hard, indisputable facts, and most of the cases do rely on the common sense that Justice Wolohojian has mentioned earlier. And I would argue here the jurors were more than able to rely on their common sense to understand that a man who had, the defendant in this case, who the victim testified had relapsed back into drug use, had frequently been drinking, terrorized her, as she described in her 911 call, ran off and was arguing with her, and then ran back and just punched her while she held this 1-year-old baby. It was more than reasonable for the jurors to conclude and more than sufficient evidence of reckless endangerment. The case law informs us that it's a very fact-specific analysis in the totality of the circumstances here. And given the age of the child, it's more than likely that the risk of serious bodily injury could occur in 2 ways, well, maybe more than 2 ways, but certainly in 2 ways, as Justice Green said, either from being the recipient of a mislanded punch or by being dropped down the stairs. I think it's clear that the Commonwealth met its burden in establishing the sufficiency there. With regard to the restraining order, I'll just mostly rest on my brief, but it's clear under the case law that a 209A affidavit is admissible.
Can I ask you about that? You say that it was a prior inconsistent statement, but when I look at her direct testimony, I can't find anything that's inconsistent with the affidavit. I mean, she was never asked, as far as I could see, she was never asked on direct examination about any prior history with the defendant.
Wasn't she asked on direct, and I'm sorry, I don't know the page, but I think it was the defense's theory all along, and her testimony on direct was consistent with this, that her arguments with the defendant were purely verbal, that there was never any physical engagement, that he had never laid hands on her.
The question, did he put his hands on you, I took to be in the context of this incident, not any prior incident.
Well,
So
it's certainly
that's correct. This would not be a prior inconsistent statement, right?
Well, right, if there's no evidence that she testified that he only ever fought with her verbally and not physically, and then it would be admissible to show the nature of the relationship, and substantively under Day and Belmer, where it was sworn testimony, and she was available for cross-examination. It's clear that a 209A comes in substantively on those grounds. So it may not have come in specifically for that reason, but it certainly
It
was.
was asked on cross-examination. I might be wrong, but I think the question was asked on cross-examination for the first time.
Okay. I mean, I know that was their theory in the motion in limine. And so that was their reason for opposing it at that point.
But it seems to me the defendant's theory of an objection is not based on the admissibility of the based on the nature of the evidence itself, but on its propriety, its probative value, and its relevance. As I understand your argument, you're saying that it was appropriate to impeach the victim's, the mother's statement that she was not in fear, and that this was not in character for the defendant.
And I think that's how the prosecutor used it at trial, to demonstrate that that their relationship did involve physical altercations, that the defendant did act unreasonably in the past in their relationship, and it was reasonable for her to be afraid of him. I don't know if that answers your question at all, but
Back to refresh my memory of the testimony.
okay.
Continue, please.
All right, so I guess if there are no further questions, I'll rest on my brief, and I will get in touch with Attorney Hughes to expedite the transfer of what I have from the prosecutor's file with regard to those exhibits and get them to the court.
All right. Seeing no further questions.
And we are back live and on the record.
Thank you. We continue our list with case number 2020P245, the Commonwealth versus Bradley S. DeFlumeri. Attorney Reardon.
Good morning, Your Honors. May it please the court. Mr. DeFlumeri went into that apartment angry because someone had allegedly said something derogatory to his wife. He was looking for Indian men and only men. There were 3 women in the living room and 1 man. There was another man in the back bedroom that never came out. Mr. DeFlumeri demanded to see how many men there were. Where's the other man? I know there are more men. No, there aren't, the victim said. And so he said, well, he pointed to Mr. Jane and said, well, you're the one then. You're the one that said something about my wife. And all of his attention was drawn to Mr. Jane, not to the women. He never made eye contact with women, according to them. He never did anything, said anything derogatory to them. It was only to Mr. Jane. I argued that they did not prove the element of threat of force against the women, and Mr. Rajan in the back room, and that the required finding of home invasion should enter for them, but not guilty.
What about the evidence that I believe it was Millie Shaw's testimony that she perceived that the threat initially was directed at the whole group? Why isn't that enough?
I believe that's when he went into the living room, when he entered after she opened the door. I would suggest that as soon as he saw Mr. Jane, which was almost immediately, he focused on him. His entering into the apartment, yelling about these alleged statements that were made were not directed at the woman.
Is the perspective here what his objective was, or the effect it had on the occupants of the dwelling? Well,
It's certainly the occupant's perception, I would say.
So if they reasonably and objectively were placed in fear by his threat, that's enough. You agree with that?
I would suggest yes, but I would suggest it was not reasonable.
These these women see a guy coming into the apartment yelling and screaming and brandishing a metal rod and issuing threats to kill any men, they are not reasonably in fear. That's your argument.
According to the facts, he actually was not, he never brandished the pipe or the metal object. He always, at all points, held it down in his hand. He never raised it.
It was visible to everyone. He did not bother to conceal it. When he got home, he described it as a tire iron. And I'm wondering why, in the circumstances, you know, targeting a house, going into the apartment, specifically sort of on the hunt to confront, on a mission to confront people he thought had said derogatory things to his wife, while visibly carrying a long metal object, maybe a tire iron. Why the fact that he's carrying it openly so that other people can see it, why is that not the equivalent of a nonverbal threat?
He was carrying it so that people could see it. I agree with that. However, the manner of use, he never, as angry as he was, he never lifted his, he never bent his elbow. He never lifted it up. He never pointed it at anyone. I would take exception to the word brandish. I don't think he brandished it. He just carried it.
Let's accept that he didn't brandish it in any raised form with an imminent threat of use. In these circumstances, for someone not to be fearful, they are made of much sterner stuff than I am.
I understand your point. However, I still stand by my argument that it was not enough. And
with respect to the second man who was in the back bedroom, if the test is whether the occupant perceived the threats and the defendant comes in threatening all Indian men to kill all Indian men, and he's scared to come out of the bedroom because of that threat, why is that not enough?
Mr. DeFlumeri didn't even know he was there.
But the victim doesn't know that.
He was not in imminent fear, in an imminent position where he was going to be imminently injured if the metal object was used. Because as far as Mr. DeFlumeri was considered, he wasn't even there. If he had beaten, God forbid, beaten Mr. Jane with a pipe, he would have left after that.
Maybe. Again, if I'm in the bedroom, I'm not feeling all that sanguine at the moment.
I understand, but and I'm not suggesting that you're not unreasonable, because it's a reasonable person standard.
We understand that you have to make your argument, and we get that.
Yes, and you know, Mr. DeFlumeri feels very strongly about this.
Right. We understand.
If there are no more questions, I'll rest on my brief.
Thank you.
Thank you.
Good morning. May it please the court, Assistant District Attorney Bethany Lynch, representing the Commonwealth. In this case, I would suggest that the trial judge properly denied the motion for required finding when it came to the home invasion charges in this case. The defendant's claim on appeal is limited. He doesn't challenge the entering, he doesn't challenge the knowing people were present, or that he had a dangerous weapon. I would suggest that a metal bar that was described as being 18 inches long, weighing between 3 and 5 pounds, and there was a photograph admitted into evidence, and it's included in the Commonwealth's appendix at page 37. The defendant had that in his hand openly, entered the apartment, and began making threats to kill the occupants. Initially, he did not see Mr. Jane. Mr. Jane was initially in the back bedroom, and when he heard the yelling, he and another, one of the women, Miss Ashita and Kit, she came out of the bedroom with him. So initially, he was threatening, I would suggest, the group, as Millie Shaw testified, was her perception. The defendant also admitted.
A question, Attorney Lynch, if I may. If I understand the Commonwealth's argument, it doesn't matter whether the defendant was only threatening a single person within the house, because in this particular crime, the unit of prosecution is each individual that was within the house. And as long as the elements are satisfied with respect to any one of them, then it's satisfied with respect to all of them.
That would be the Commonwealth's position. Yes, Your Honor.
Do you have a case for that?
I believe that the cases that I relied on were Anton Marchi, where it describes there being the term any person being defined as one, some, any, or all. And also, to a lesser degree, the Martinez case, which was 85 Mass Appeals Court 288, which that describes more the fact that the Commonwealth is not required to prove that the defendant knew of the presence of any specific victim. So as long as, I would suggest Anton Marchi holds that there does not need to be a specific threat to each and every individual in order to satisfy the home invasion statute.
Anton Marchi and the other cases you cite came up in the context of duplicative convictions. It doesn't answer the question whether each element of the offense has to be met as to every occupant. So, so if your position is that all you do is count heads, let's say there's this house party with 100 people going on, and the defendant enters a different part of the house and threatens one person in that part of the house. Now he has 100 convictions?
No, I believe that it would need to be more than just that the threat needs to go to one person, but that the fear of the threat, that the threat could spread, would go to the others. So the others would have to perceive a threat, whether or not the defendant specifically intended to threaten anyone individually. As long as
that perception would need to be objectively reasonable.
Yes, Your Honor. And I would suggest that it was in this case, even for Mr. Rajan, who was in the back bedroom, because he heard the defendant yelling as soon as he came in. I believe it was Millie Shaw said he has a metal rod. So Mr. Rajan in the back bedroom knows that there's a man unknown to him yelling threats of violence in the outer room, threatening Indian men, and that he was armed with a bar. He heard all of those things, and he testified specifically that he was afraid. He was too afraid to call 911 because he didn't want to give away his position.
Okay, so if the facts were that the defendant came into the house carrying his metal bar, and he pointed to just one of the occupants and he said, "I have no beef with any of the rest of you. You're all fine. But this person I have a beef with, and I'm gonna, kill you." In your view, that standing alone would not be enough to prove home invasion with respect to the people who were not directly threatened.
Unless the people
I said standing alone, because unless they had some objectively reasonable fear of a threat that encompassed them.
Yes. I mean, if it was a very specific threat where another individual had no fear whatsoever that the armed man standing in the apartment might hurt him as well, I would suggest that would be it would be based on the evidence that was presented as to whether if that person testified that they had no fear, or the Commonwealth did not have any evidence that they felt the least bit threatened by what was going on, then possibly that's a much closer case as to whether a required finding would have been appropriate.
Isn't this case similar to Justice Wolohojian's hypothetical? Because as I recall the testimony, the defendant said, "Not you girls," and he made clear that he was looking just for men.
At one point he said that, but throughout he is brandishing he's holding the weapon, and he is advancing on both men and women. He's advancing on the woman in the hallway. He's trying to get to Mr. Jane and towards the back bedroom. So I would suggest, and that the defendant himself stated that he threatened them all. He threatened them with the tire iron, or with,
I see where he threatened them all. When the officer was outside his apartment and heard a male voice and a female voice, the testimony was he threatened to kill them. That's
I'm sorry, yes.
Whether he's referring to just the men or the whole group.
But at the time, there was no evidence that he was aware that there was another man in the apartment. So as far as the evidence, he knew there was one man and 3 women, as far as what he would have perceived. So, and I think that the fact that the women felt in fear, they were in a small enclosed area. He was a very angry man, according to all the testimony. He's using profanity. He will not leave the apartment. They said that as he got angrier, he was holding the pipe or the tire iron tighter and tighter. They were very afraid that he was going to be able to use it. It was close quarters, and that it wasn't until he left, they were able to get him to leave the apartment that that they felt the least bit relaxed, or that their fear level went down at all. And even still, then the defendant came, or a voice similar to the defendant's returned to the apartment to bang on the door. And to at least Ms. Jane, and I believe Mr. Jane, and I believe Ms. Ankett testified that they were still afraid the next day. So this was a very threatening incursion into their home. And because of that, all of them, I would suggest, were victims of the home invasion, not just the man that he ultimately focused on. When he first entered the apartment, he didn't even see the man, and he began yelling threats. So I would suggest that that would be enough to satisfy the elements of use or threatened imminent use of force under the home invasion statute. If the court has no further questions, I would rest on the Commonwealth's brief.
Seeing none, thank you. Thank you.
And we are back live and on the record.
Our next case, and the last of our 3 criminal cases this morning, is case number 2019 P1368, the Commonwealth versus Kimberly G. McNair. And just as a reminder, at the conclusion of the argument in this case, for those who are watching, we will take a very brief recess before resuming with the civil portion of the list. Attorney Neff, you may begin.
Thank you. Good morning. May it please the court, Susan Neff, arguing on behalf of the defendant appellate Kimberly McNair. This appeal deals with multiple issues, but I would like to use the time I have to address the judge's reliance on inadmissible evidence, the lack of apparent authority, and the fact that Mr. McNair didn't receive a fair trial, both because of prejudicial joinder and because of errors that, when accumulated together, created a substantial risk of miscarriage of justice. I'd rely on my brief for the other portions, other arguments, unless the panel has questions specifically relevant to those issues. In this case, the lower court's denial of Mr. McNair's motion to suppress must be overruled because the judge relied on inadmissible evidence and clearly erroneous facts in his finding of facts and ruling.
May I ask you a question?
Sure.
When you use the phrase inadmissible in this context, are you referring to inadmissible under the rules of evidence? Because the rules of evidence don't apply.
No, I'm sorry.
In motion to suppress, in the context of hearings on motions to suppress.
No, I'm referring to them as inadmissible because they are evidence, particularly the recording of the 911 call and the radio transmissions are evidence that include evidence and facts that weren't known to officers at the time. And so it shouldn't have been admitted.
It shouldn't have been considered because it wasn't legally relevant. Is that what your argument is?
No, no. My argument is that in deciding a motion to suppress, the court has to rely on facts known to the officers at the time of the entry and search. And the material that was on that recording contained information that the officers did not know at the time of the enter and search.
That argument seems to me, as you phrased it, to go more to weight than admissibility. But it also, I think, to Judge Wolohojian's point, relates to its relevance. And that would be a ground to say that it's inadmissible. But I guess I have some vague recollection that there is a doctrine that treats knowledge of police as collectively held. It's something of a legal fiction, but I think that that is the state of the law.
That's true, but the 911 call and the radio transmissions weren't testified to by an officer, weren't addressed or issued or entered or offered as collective knowledge. The things that Officer Fritsch testified to, I think you could apply that to.
So the 911 call was not fielded by a member of the police?
I'm sorry?
An officer did not hear the 911 call?
Not prior to entering and searching the house. And it might clarify a little bit if I say that the problem with that and the reason why it is inadmissible is that it creates facts that are clearly erroneous.
I guess I'm having trouble seeing, even assuming that the judge relied on that evidence and shouldn't have, I guess I'm having trouble seeing what the prejudice is. I mean, we review the conclusions of law de novo. So, the officer testified that before they arrived at the building, it was already broadcast. The substance of the 911 call was broadcast, even if the specifics weren't, and that he knew that the defendant had a history of firearms convictions and a history of other abuse. So, given that testimony, why does it matter that the judge listened to the 911 call? Well,
Specifically, it relates to the judge's finding of apparent authority, because the judge put in his rulings of facts that were not supported by the record, and particularly facts that lent themselves to his determination of apparent authority.
Which specific findings do you argue are clearly erroneous?
In his findings of fact,
maybe we can refer specifically to the decision. That would be helpful. So I'll just highlight them. What are the specific factual findings that you contend the judge made and that were clearly erroneous?
Well, I think the answer is that there are a number of quoted statements and statements made from the voice and the hearing of the 911 call that were not available to officers. Officers never heard Miss McNair say she's very frightened. They never heard her tone and manner of speech or that it was discernibly frightened. They never heard that she didn't want anyone to know that she called police for fear of reprisal, not for some other reason. And they never heard, just get him out of here with that gun. And all of those things were listed in the facts and went to and influenced the judge's decision.
Well,
as to apparent authority.
Why? Apparent authority, why? Why does any of that bear on apparent authority? As a legal matter.
As a legal matter, a finding of apparent authority requires both facts reasonably found that would suggest that the person had authority to consent, and those facts should be found on should be facts available to officers at the time from which they can determine that she reasonably appears to have.
Sure.
And that
let me just maybe paraphrase in a very simple way. If a person says, this is my apartment, I live here, and there's a gun in the coffee table I want removed, officers, please come and do that.
I think I addressed.
I think we could all agree
Sorry.
that that would be sufficient to give both actual and apparent consent to the police to enter the person's apartment to remove
Well,
the gun.
I'm sorry. I would agree with you, except a really interesting point in this case is that all of the cases that the Commonwealth cited and relied upon were cases in which the consenting party was inside of the premises. And when someone's inside of a premises, it at least lends support to the fact that they have authority over the house.
Okay, but it can't possibly be required that they remain in that house, right? Like, what if the object that they want removed is a bomb? You're going to say, oh, in order to give consent to the police, the person has to remain in the apartment with the bomb? That can't possibly be the rule, correct?
No, I'm not saying they have to. I'm just saying that the Commonwealth didn't cite, and I haven't found a case where the person who's giving consent is outside of the premises. And
But the rule is that the police have to have a reasonable basis to believe the assertion by the person telling them that they live there, that in fact they do live there, right?
Right.
Okay, so she told them that she lives there. What is, she doesn't have to produce a copy of the lease. Again, these are real world exigent circumstances.
Mm-hmm.
So she's not going to go running out of the apartment from the bomb or the gun, but first rummage through her file cabinet to get a copy of the lease so that she can show it to the police. She tells the police, I live there and I'm afraid. Isn't that enough?
No, I don't think it is.
What else would she have to do?
I think that there has to be something to support her assertions.
Give me an example. Give me an example that attaches not just to this case, but to real world practical circumstances.
I think that the officers have to ask questions sufficient to satisfy them.
Okay, tell me what those questions are.
Well, I think it depends on the.
Let's talk about this case. Let's talk about this case.
The only indication that they have that she was connected to that apartment was her say-so.
Right.
And she's
okay, so what
outside.
else? I'm trying to ask you, what else should they have done that would, in your view, satisfy the additional requirements that you suggest apply?
Well, I think they should have questioned her before they went upstairs. I mean, in this
Tell
case,
me again. I want to know what those questions are and what would they be designed to elicit, and how would they add anything more, because the answers to those questions would still be based on, as you put it, her say-so. But tell me what those questions are.
They could ask her name. They could ask her questions about the building that they could confirm. They could ask her questions about her date of birth. They could get information over the radio about her. They could get
information over the radio. I mean, this seems to me to undercut your argument that the 911 call is inadmissible. During the 911 call, they asked for her name, which she was initially reluctant to give, the address, the specific apartment number, the name of the defendant, his date of birth, their history. They did ask questions. And to the extent that your argument is that she needs to be on the premises when she gives consent, or inside, because arguably she was on the premises because she was on the front stoop, but that she needs to be in the specific apartment. She was in fact in the specific apartment when she called 911.
So, I mean, I'm not saying that she has to be in the apartment. I'm just saying that this is an issue where being in the premises lends some credibility to the person who's claiming consent. The problem here is that all of those questions that were asked by the operator, the 911 operator. So the question is, what was transmitted to the police before they went upstairs? And what was transmitted was very, very little.
But it constituted it would have satisfied each element of consent.
I don't think
it was that The woman who lives in that apartment, reports that her husband has put a gun in the living room coffee table, and she wants it removed and him.
That's what part of that is what officers heard over the radio transmission.
Right, so if they take that at face value,
But I don't think you can take it at face value. When they arrive on the scene at 11 o'clock at night, there's a woman standing outside of a building, and the only thing they know is that a woman called 911 and said her husband was in her apartment with a gun in the coffee table.
And this woman that they see at 11 o'clock at night standing on the stoop outside of that apartment tells them that she is that person. It seems to me to be the sort of corroboration that ties the pieces together.
I don't think they even verified that she was Colleen McNair before they went up the stairs. I mean, they just saw the woman there. They have a report. They have a report of a woman who was outside of her apartment, and now they get to the apartment and they see a woman outside of the apartment. No, they didn't have a report that she was outside of the apartment. They had a call from someone who said that her husband was in her apartment with a gun. They never heard that she was outside. And you could walk, I mean, the point I'm getting at here, Your Honors, is that if this was allowed to stand, what's to prevent any single person who might want to get someone in trouble or cause, some kind of an incident from calling 911 and say, hey, my name is Sally Smith and my husband's in my apartment with a gun. And meanwhile, they're standing outside the door.
Well, they can give consent to enter. And if the police go inside and it turns out there's no gun, then they've given consent. But the question is the constitutionality of the entry, and whether they, I can give authority to the police to enter my apartment, whether there's any illegality going on in my apartment or not. Hopefully there's none.
Yes, but you're giving consent to your apartment and presumably the police know who you are. I mean,
I don't know.
Again,
I'm not, I hope they don't.
well, I don't think that you can just call 911 and say that something illegal is happening without some sort of verification of the fact that, first of all,
That's a wholly different question from the question of authority to give consent to enter.
I'm sorry?
That's a wholly different question. The propriety of calling 911 is a wholly different question from the question of whether someone has authority to allow to give consent to enter a dwelling.
And may I ask you one last question? And I realize your time is extremely short. It sounds to me like what you're saying is that the police can't just take at face value what's coming in over a 911 call. I think that's probably wrong, unless there's something to indicate to them that there's a reason not to take a 911 call at face value. Otherwise, how would the 911 system work? It's just impractical. My question's not done. So my question to you is, is there anything in the record here that would have suggested that the original 911 call was unreliable? The information in that 911 call was unreliable.
May I take the time to answer?
Please.
I think that this, maybe I'm not making myself clear. I'm not suggesting that they had to say that the 911 call, the information 911 call was erroneous. What I'm saying is that the information they received, having not heard the 911 call, was insufficient for the police to make a determination that the person who was outside the building had apparent authority or the right to authorize the entry into the apartment.
I think we have it. Thank you.
Thank you.
For the Commonwealth.
Good morning, Your Honors. ERIN E on behalf of the Commonwealth, asking this court to affirm the defendant's convictions. I'll start off with the apparent authority issue. As Your Honor noted, Justice Wolohojian, hearsay is admissible at the motion to suppress. The 911 call was properly admitted. I do believe that the information goes to weight, but even outside of that 911 call, or the judge having listened to that 911 call, Officer Fritsch did in fact testify to all of the information that the judge relied on when he made his decision. I would point the court to page 8 of the motion judge's decision, which is Record Appendix 82. Everything that's in that last paragraph that he relies on in terms of facts to support what he calls at least apparent authority, which I would agree with. I think there's actual authority here. At least apparent authority is in fact testified to by Officer Fritsch, pages 7 through 13 of the motion transcript. So everything that's in the 911 call, though he may have quoted Ms. McNair's quotes from the 911 call, the general information and facts that were contained in that 911 call were in fact relayed to police before they met with Ms. McNair, and then when they met with Ms. McNair, she did confirm those details. I do believe that the defendant's reading of the CAD sheet stating that the police went upstairs before they even met with Ms. McNair, it is in fact wrong. I do believe when they say they're inside the unit, it meant the cruiser, because if you look at the way that the facts played out, they met with Ms. McNair before they went up, and that is what Officer Fritsch's testimony was. So I do believe that they had all of this information before they went upstairs, and the actual authority of being an occupant was enough here to show that she had that authority by, this was her apartment, her husband stays there from time to time. She had made the phone call. Yes, she was standing what I would say was an open door, was the testimony, open front door down the stairs, but the testimony was also that there was one apartment upstairs. Again, this is at 11 o'clock at night. This isn't 3 o'clock in the afternoon. The fact that she's standing in front of the front door, open front door, or inside the open front door of this apartment stairway would lend credence to the fact that it is, again, she is a resident there. And in any event, the defendant did not object at any time to any sort of consent search that was about to happen.
There was something like 3 minutes between when the 911 call was made and when the police were speaking to the caller at the front of the house, correct?
Correct, Your Honor. Officer Fritsch's testimony was that once he was given the dispatch, he wasn't that far away, and he proceeded directly over there where he met Ms. McNair outside. And again, to that inside-outside argument, you have to look at context here, and I think that's, you know, every case you have to look at context. The context of this case being she was fearful for her life. Her husband, who's known to beat her, has a firearm in the apartment, so she gets out of that apartment. She also doesn't want the police to know she doesn't want her husband to know, excuse me, that she called the police, which would lend credence to the fact that she is standing outside downstairs because she doesn't want him, who was in the apartment, to know that she called the police. She doesn't want to be in that apartment when the police knock and announce. So those are very credible reasons that she would be standing downstairs waiting for the police. And also the fact that she wanted to meet them and give them the information and confirm that she does want them to go in there and get her husband out of there with that gun.
Can I turn your attention to some other arguments that the defendant has made? On the motion to sever, let's assume for a moment that the 209A charges had all been based on events that occurred a year earlier. So in other words, not the one that occurred, not the second episode that occurred just a day or two before the firearms charges, but only a year earlier. How would that have been, how would those two have been properly joined for a single trial?
Sure. So first and foremost, I would just, point the court back to the Rule 9, 9A3, a judge shall join related offenses for trial. And I think that shall language is instructive.
What does related mean?
Sure. Well, I'm sorry.
In the example I posited, how would those two be quote related within the meaning of the rule?
Sure. Well, first and foremost, it's the same victim. And I understand that that does happen in multiple cases where they are, eventually tried separately. But here, not only is it the same victim, but the case law regarding domestic violence in those relationships is clear that the judge has a discretion to kind of allow multiple incidents to show the nature of the relationship. And I think here,
how would that come in on the firearms charge? If the firearm charges had been charged alone, first of all, the wife wouldn't even have been a necessary witness, right? To that.
I think that the wife would have been a necessary witness
to prove that a possessory offense.
I would say so. I think that yes, because where she had said that it was her apartment and then that gun was found in her apartment. And then you also need the context of how do you even get there?
What elements would that go to? What are the elements of the firearm charge?
Well, yes. So you have to prove that the defendant had possession of that unlawful firearm, and her testimony is the one that gets them into that apartment that finds that firearm.
Well, no, her testimony is essential for on the motion to suppress, but that's a pretrial proceeding. Once the ruling on the motion to suppress enters and the evidence is admissible, that testimony will not be necessary at trial. So on the possessory offense, the police testify. We went into the apartment. We found this firearm. Her testimony is entirely unnecessary. It seems to me, unless you need her testimony somehow to establish that the defendant lived there and had control over it, and that can be proven in many, many different ways.
Including that he just walked out of the apartment when they went up and knocked on the door, and he had the loaded magazine in his pocket.
Right.
So, I don't understand how, if that had been a standing alone set of charges, you would get in any evidence about the nature of the relationship between the wife and the defendant.
Sure. So if I may just back up a little bit to Chief Justice Green's comment, I believe that even though that is true that the police could have taken it from there, her information regarding the context of the situation gave, the Commonwealth is allowed to present the story, the context of how we got there. And we can't just say the police showed up and went in and there's a gun. We do have to tell the jury how that came about. And that there was.
That, again, even if she can testify that she gave them consent, and although they could testify that she gave them consent, to go back to Judge Wolohojian's question, the context, the history of their relationship is immaterial to the question whether he had possession of the firearm that the police obtained when they went into the apartment.
I think that here, though, you really have to focus on the context of the case, and that the call for come and get the firearms was based on her state of mind, her fear of him due to these other events, due to this relationship. They really are inextricably intertwined because Ms. McNair, it's a progression. And this June incident with these firearms finally ends that progression. And if I may, sorry.
This is why I began by saying remove the incident that was just a couple days before the firearm discovery and look at just the first 209A charges, which were from a year before, and the firearm charges. How on what basis can those be joined for trial together?
Well, I also do believe that those August charges, if you look at the way that they were brought, she was in fact intimidated by him to not testify in those August charges, the domestic violence related charges. And then coming into this trial with the firearms charges, the defendant's defense was credibility of Colleen McNair. And so, giving her the credibility to say, yes, he intimidated me into not talking, into not testifying about those first charges. That's why we have them here again. And that's why, I'm able to testify today because I finally was able to get out from under his thumb type of thing. I would also point to the fact that the jury, in fact, acquitted him of the ABDW wall, ABDW mirror, and the threats charges, which shows that the jury considered these charges, did in fact consider the charges individually.
The defense on the firearms charges was credibility, and that it was in fact her gun and not his gun, which would make her testimony necessary, it seems, if there was a separate trial on the firearms offenses. Now, let's say there was a separate trial. Would the evidence of the earlier 209A offenses, would that make her testimony more or less credible, or would it not be relevant at all?
That's a hard question, Your Honor, because I think, there would have to certainly be discussion. I do believe that they're relevant in terms of the relationship if he's trying to, say, pin it on her. There was no evidence that was exculpatory in terms of her fingerprint on the firearm or anything of that nature. Her testimony had always been that they were his guns, that she knew he had guns, that the secondary gun was actually found in the trunk of his vehicle, and she pointed the police to that that June night. So I think they are relevant in terms of, again, the relationship between this couple and how things played out. And I don't think you can necessarily take it piecemeal just because of the relationship, and the case law, talks about the domestic abuse relationships and how you're able to kind of show the nature and why the victim did certain things that she did. And so I think that here, had there been a separate trial on those firearm charges, there would, one, at least certainly have been a discussion about, one, if they were prior convictions, if they hadn't been prior convictions, if they, are prior bad acts, just the general nature of the relationship in the past, and that fact that she didn't testify against him beforehand in that first trial, we'll call it, which ended up having to be no pros because of her lack of cooperation due to the intimidation from this individual. So really it goes to her state of mind, why she feared him, why she feared there was a firearm in the house. And I think that here severance just didn't make any sense, and it was under that shall language to keep them together was more cohesive. And in any event, like I said, he was acquitted of 3 of those domestic violence charges.
If there was a separate trial on the 209A related offenses, how would the evidence of the firearms be admissible in that trial?
In that trial, I guess we would have to sit down and decide exactly which of the domestic violence charges would have been in that trial, because as Justice Wolohojian pointed out, there were a couple others in the interim. If you had just proceeded on those August charges that were originally charged, the ABDW wall, for instance, I don't know that it necessarily would have, because they were they were events afterwards. Certainly, I think that here in this case, when you look at it as this case is and not through a hypothetical, it's context, it's why she did what she did, why she feared him. Again, the judge instructed very forcefully on the individuality of the charges, and I think that here, the jury are presumed to follow the judge's instructions, and did consider them individually by acquitting. But I would say that if the 209A, was separate, you would still get in nature of the relationship. You would still get in why she is scared of him and things of that nature. And I think that, the firearms coming after present a little bit of a wrinkle if you had separated them. But again, it's within the judge's considerable discretion to keep them, and it's a shall language, to keep them together as long as the best, it's not outside of the best interest of justice. And here,
the fact that links the 2 sets of offenses is this threat that he made in between, that I'm going to put a bullet in your head.
That's
like,
one of.
Without that, it's hard to see the connection between the sets of offenses. So if A is related to B and B is related to C, then all evidence of A, B, and C come in.
Well, again, as the prosecutor explained, when talking about severance, these events were a span of time. They talk about the nature of the relationship. They talk about the fact of why she did certain things, why she didn't testify in that first trial and it had to be no pros, why she didn't leave him, which is a huge concern in domestic violence cases, of juries just wondering why she didn't just leave, which we know, you can bring in evidence as to that type of information. And I think also it's just the buildup. And here you can't take out that threats in the middle because it is part of this case. If there hadn't been that, and there hadn't been that witness intimidation, this might be a better case for severance. But here, under that shall language, and where the judges in her discretion determined that they were inextricably intertwined, it was proper to keep them together. And if this court has no further questions, I'll rest on my brief.
Thank you. Thank you both. The case is submitted. We will take a brief break and resume at 10:55, 5 minutes of 11.
Should I be beginning, Your Honor?
And we are back live and on the record.
Thank you. The next case on our list for hearing is case number 2020-P1308, EFFSATHIA Lacusas versus Makris and another. Attorney Sano, you may begin.
Thank you. Good morning, Justices. Good morning, Attorney Rubin. This case involves a single-family home at 62 Milton Street in Lynn. Louis Makris and Sophia Makris are the parents of EFFSATHIA Lacusas. In 1993, and I'll start at that point, and Mr. Makris already was an owner of 62 Milton Street. And apparently he was having problems paying the mortgage. And the property was deeded to his daughter, Christina Picos. And he applied for a restructured financing with Bristol Mortgage Corporation. And the property was deeded from Mr. Makris to his daughter for a sum of $132,000. And she applied for and was granted a mortgage for $104,000. However, it is agreed by all parties that there was no $132,000 paid.
Attorney Sano, we do have the factual background, and I think your time is limited. It would be helpful to, as I understand it, you're challenging the basis for the jury to have reached its verdict in the main, and I think if you would direct our attention to the reasons why the evidence was inadequate to support the jury's verdict, that would be helpful.
Thank you, Your Honor. Your Honor, in 2001, the property was sold by Christina Picos to my client, EFFSATHIA Lacusas. And it was an ordinary deed from her to EFFSATHIA. The deed was drawn by an attorney. Title search was done. The deed recited it was for no consideration, but it was subject to a mortgage for a little north of $93,000, which was thereafter paid off by Miss Lacusas. Later on, the Makris family has alleged that my client was actually holding the real estate in trust for them. She denies any such understanding. Testimony from the attorney at trial was that there was no mention of a trust. My client thereafter.
Attorney Sano, there are various ways for the law to find a trust, right? There can be a resulting trust, a constructive trust. There doesn't have to be a written trust declaration in order for a trust to arise. The jury in this case apparently concluded that your client stepped into her sister's shoes, holding the property and paying the mortgage using her parents' funds. And the reason that the property was transferred in the first place to her older sister was, I believe she was the older sister, was to allow the older sister to get a reduced interest rate on the mortgage. And that was the only reason why title transferred at all. Now, the jury accepted that version of events. There was conflicting testimony, conflicting evidence, but why is it impermissible for the jury to resolve those conflicts in favor of the parents and adversely to your client?
Well, first of all, Your Honor, there was never any issue brought up as to a trust from the time that my client acquired the property until some 16 years later, when she started an eviction action because the parents were allowing.
But the trust in these circumstances is more of a legal conclusion to describe the nature of the relationship that arose from the facts as they unfolded. It doesn't matter whether anyone ever used that terminology among the participants of the transaction.
Well, the understanding of my client, Your Honor, was that she was the sole owner of the property. She had no reason to believe otherwise. She subsequently financed the property. In 2007, she acquired an adjoining piece of property from her brother. And she always dressed herself with all of the vestiges of ownership.
That was her version of events, and she certainly was entitled to present that to the jury. The parents presented an alternative description of the circumstances and arrangements, and the jury was tasked with the obligation to resolve the legal effect and also who was telling the accurate story.
No, I understand that, Your Honor, but given the evidence that was presented, it was overwhelmingly in favor of my client in terms of what actually happened, what the documents actually reflected, and the in essence also there was actually no reason to have a trust. If the parties, or I'm sorry, if Ms. Bikos and Mr. Makris wanted to do something different, they could have, but they chose, Mr. Makris could have just held the property on his own, but they chose to deed and transfer the property to my client. And I would say that the rationale behind it is that there was this outstanding mortgage. They were having financial issues, and my client was ready, willing, and able to take ownership and to pay off the mortgage. And
I know this is sort of a variation of Chief Justice Green's questions. I know you know this, but we are going to have to work on appeal within the legal framework that binds us. And that legal framework instructs us that at this point, we need to accept the jury's determinations of fact. And that means reading the evidence in the light most favorable to the party that they found in favor of, including drawing all reasonable inferences from that evidence and accepting credibility determinations that the jury made. So as far as I can tell, your arguments are asking us to do something other than that and to reweigh the evidence, the conflicting evidence. There is no doubt that there was conflicting evidence, but can you give us some legal authority for the proposition that we can reweigh the evidence on appeal? I don't think that's the law.
I understand, Your Honor. The basis of my appeal was that the finding was against the weight of the evidence. And what I'm saying is, regardless of what the jury determined, I feel that on the record and with all the evidence that was presented and all the factual material that was provided, that the finding was incorrect.
If the jury believed the parents and the first sister who owns the property, why isn't that enough? In addition, disbelieved your client. Why isn't that enough to sustain the verdict?
Well, my answer, Your Honor, would be that the reason for filing an appeal, obviously, is that you're aggrieved by the finding. And my argument would be that the review of the transcript, the review of both briefs would or should lead to a different conclusion, that in fact the jury did err in their finding, and that based upon everything that was presented, the time that had elapsed in this case over 17 or 18 years, that it simply is not credible that the jury should have found for the Makrises. Part of my contention there too is that over and above everything else, in terms of consideration, not only was the $93,000 mortgage paid off, but in addition, the Makris benefited from the acts that took place in 1993, obtained the benefit of this $94,000 mortgage, so that in essence, and I'd argue this to the jury, the benefit to them, to that family, was almost $200,000 if you couple both of those. And so in terms of how could you find that Mr. Makris still had an ownership interest in that property and trust when he had received this amount of money and based upon the conduct that he had engaged in?
May I ask you a question about the unjust enrichment claim?
Yes.
So you make a couple of arguments on appeal that relate specifically to that claim. And I may be misunderstanding the judgment relative to the verdict, but the jury returned a verdict on both the breach of contract counterclaim and the unjust enrichment counterclaim. But then the judgment, and am I correct that judgment entered only on the contract damages?
Well, I know that the total damages awarded were in excess of $600,000, I believe.
I thought that the verdict was $516,000 on the contract claim and $353,000 on the unjust enrichment claim, but then judgment entered only on the contract damages. Does that sound right to you?
Yes, it does, Your Honor.
Okay, so if that's the case, then how is it that there's really any issue on appeal with respect to the unjust enrichment claim?
Yeah, there wouldn't be, Your Honor. Okay.
Okay, that was what was confusing me. Okay.
Yes.
Could I ask you a question about the record? So your arguments about parole evidence in unclean hands, your brother says that they were raised in your summary judgment motion, which was denied, but then not resurrected at trial. Is that accurate?
Well, the parole evidence issue was raised in the pleadings. I did not raise it directly, but my contention would be that, as a matter of law, the fact that you had a written instrument that the parole evidence would bar, except in very limited circumstances, any introduction of verbal agreement or verbal understanding.
If there was no objection at trial to the production of that evidence, then how does that remain a live issue for review?
Well, my contention, Your Honor, would be just as a matter of law. In fact, there was no evidence introduced that would, other than conflicting contentions, that would moot the issue of the parole evidence rule.
I think that it's maybe a variation of the parole evidence rule that you're arguing, because here, the counterclaim was based on an allegation that there was some kind of oral agreement that created a trust of some sort. And your argument is, because parole evidence is normally used to try to explain something about different than what's in a written contract. Here, it's really they're using evidence to try to establish an independent oral contract. That's not normally called parole evidence. I think what you're saying is when there exists a written contract in the form of a deed, you shouldn't be allowed to try to prove a contradictory oral contract.
Well, that's substantially correct. And I know that rules in regard to deeds are very strict in that regard.
Yeah.
I see that your time has come to an end. Unless there are further questions from the panel, we'll hear from Attorney Rubin. Attorney Rubin, you have to unmute yourself.
Thank you for that reminder, Mr.
If
Chief.
If I had a nickel for every time I've had to say that over the past year, I could retire.
Well, I appreciate it all the same. Thank you, Mr. Chief Justice, and may it please the court. As you seem to be aware, the jury was asked on a special verdict whether a contract existed between the appellant, EFFSATHIA Lacusas, and her parents, the appellees, Louis Makris and Sophia Makris, and the jury said, yes, the contract did exist relating to ownership of the home. The jury was asked whether Lacusas breached this contract and said that she had. The jury was asked what the damages were for this breach and gave an answer. The trial judge was then asked whether this verdict was against the weight of the evidence, and the trial judge, who sat through the same testimony and evidence that the jury did, said that the verdict was not against the weight of the evidence. Lacusas now wants this court to second guess not only the jury, but also the trial judge. And that is a very, very heavy lift, at least under controlling law in Massachusetts.
Well, at least as to the determination made by the trial judge was making a determination of law based on the record. We review that same evidence with the same question of law under consideration. We don't extend any particular deference that I'm aware of to the determination of the trial judge. I mean, we certainly would give it some thought because the trial judge, as you say, was there at the trial. But the question that we are being asked to do is the same question that he was being asked, and that is whether the evidence could support a rational jury in reaching its various answers to the special questions.
Chief Justice Green, with respect, I'm not sure I agree with that characterization of what's before the court. In Lacusas's motion for a new trial, it was premised only on the notion that the verdict was against the weight of the evidence. It wasn't a directed verdict motion that no reasonable jury could find, or a judgment notwithstanding the verdict motion that no reasonable jury could have found. This was a question of whether the verdict was against the weight of the evidence. And there is substantial precedent in Massachusetts that when a judge makes a determination on that question, that determination is reviewed for abuse of discretion. And while reversals of such determinations have happened, it's been written that they're like snowstorms in mid-May. Such occasions may occur, but they induce considerable astonishment when they do. And this simply is not a considerably astonishing case in that regard.
I stand corrected.
One of the things that surprises me here is that I'm familiar with a number of cases where usually parents have transferred ownership of a real estate to their children or a child in the form of what might look like a gift. And but the argument later is that it wasn't in fact a gift. It was transferred as a constructive trust. or a trust for their benefit. But I'm not aware of any case, and I'm hoping you're going to point me to one or two, where that happened when the property was transferred for consideration.
Well, I don't think that is the case here. For one thing, the claim was brought against Lacusas, and that while there was some testimony that she gave consideration that was not stated in the deed of assuming the mortgage, there was conflicting testimony that the mortgage payments were still made by the Makrises. There's not really anything to
The
support.
original transfer to the other sister was for consideration. I mean, unless you're telling us that the deed was false.
I think that the evidence at trial would tell you that the deed in that regard may have been false. Both Mr. Makris and Ms. Bikos testified that there wasn't actually any money that changed hands, and that the recitation of consideration was at the bank's behest in order to qualify for the refinance loan.
But why isn't there consideration in the form of the daughter taking on an obligation on a mortgage in her name that she did not have before?
So the understanding of the parties, both in 1993 and then later when Lacusas stepped into Bikos' shoes in 2001, was that while the legal obligation may have been in the name of one daughter or another, that within the understanding of the family and of the parties to the agreement, that the still be made.
That's not going to help. That's not going to help when someone doesn't make the mortgage payment. That's not going to help the daughter. She's not going to be able to go to the bank and say, oh, don't foreclose because it's my parents were supposed to make the payment, not me. Don't come after me. That's not going to help, right? Let's just assume that I at least see consideration for each one of the transfers of title. And so I'm hoping again that you'll give me a case or two where when there was consideration for the transfer, we nonetheless held, or someone's held, that in those circumstances, you can nonetheless find a trust was created for, and that it wasn't actually a transfer, but rather something like a gift. Or it wasn't really a transfer for consideration, but a gift, and a trust resulted. Do you have any case that's like that?
I'm not certain of the exact particulars of the Mulvanity case that I cite in my brief. It's a 1996 appeals court case, which is at, I apologize, it's at 40 Mass Appeals Court 106. So again, I'm not 100% certain of the particulars of whether there was consideration recited in the deed. But otherwise, the facts are very similar to the facts as they were believed, as they were understood by the jury in this case, which is that there were transfers that were going on, but the understanding of everyone at the time that the transfers were going on was that the parents retained their interest, which in Mulvanity was a life estate. Here it seems to have been beneficial ownership of the home, regardless of the transfers, and so
How do we square that argument with the fact that in the summary process action on the direct claim, on the main claim for for possession, the judge found that the plaintiff was entitled to possession?
So I'll admit that that when that occurred in 2018, it came as a bit of a surprise, and was a bit of an idiosyncratic move on the part of Judge Kerman, may his memory be a blessing. But I think that looking at what Judge Kerman was looking at and understanding the case as Judge Kerman was understanding it, and as he ordered, what he was really doing was trying to effectuate either a constructive or a resulting trust. and that by ordering that the home be sold, that the proceeds be held in escrow pending an accounting, that's exactly what he was doing. As for his entry of judgment.
Well, no, I mean, that piece of it, okay, but the first thing he did was that he found that EFFSATHIA was entitled to possession. And I don't know how he could do that. He knew that the counterclaims were in the case. And I frankly, I have a hard time understanding how the ruling on the claim for possession does not in some way have some kind of collateral effect on the arguments you're making now.
I think, so when that ruling came in, it was sua sponte on a claim for which the Makrises did have a jury right, without there having been a motion for summary judgment.
Did you move for reconsideration?
We did, Your Honor.
And that was denied.
It was.
And no one's challenging that ruling on appeal.
Well, because the home has been sold, that particular question as to who has possession of the home seems moot. It didn't seem to be the kind of thing worthy of appeal. Because neither party can have possession of the home going forward.
But that's a legal determination as to who's entitled to possession.
There are many legal determinations that can be no longer relevant because of changes in the circumstances.
No, but the effect of the judgment is moot, but the legal determination embedded within the judgment for possession is title to the property, and that's a legal conclusion.
And had it been raised at trial and perhaps an objection to the jury instructions or some suggested jury instructions regarding how that should be handled, or perhaps a motion for a directed verdict, then there perhaps would have been the opportunity in the trial court to have clarified those issues, but it wasn't raised at trial, what legal effect that should have had. And so I think it's a little difficult to go back now that the jury has found that a contract existed and what the import of that contract was and what the harm of the breach of that contract was to suggest that the entire arrangement may have been different.
Can you explain to me, and I understand that judgment, I mean, and please correct me if I'm wrong in my understanding of the judgment, but judgment entered only on the contract damages award, is that correct?
That is correct.
Okay, can you explain to me what the difference, can you explain the difference in the measure of damages on the contract claim versus the unjust enrichment claim?
Certainly, Justice Wolohojian. On the contract claim, the measure of damages when it's available is the expectation of the parties in the contract.
Well, I know it's a general principle of law, but in terms of these numbers here.
In terms of these numbers here, I think that what the jury probably did, God bless you, Justice Wolohojian.
Oh, excuse me, sorry.
I think what the jury probably did in reaching its verdict was to look at what the Makrises had established they had been promised, which was the home, with the caveat that the mortgage that had been taken out in 1993 still existed. And there may have been some unsophistication in 2001 as to how that would have been effectuated, but the understanding was that that was the mortgage that was being paid. And so I think that they took the value of the home as established by its 2019 sale and subtracted from it what would have been left on in terms of payments on the 1993 mortgage.
Okay, what about the unjust enrichment?
On unjust enrichment, it seems that what the jury did was to add up the amounts of the home equity line of credit and the refinance mortgage that were taken out in 2017. And
okay, because there was evidence that those were used for the benefit of the plaintiff rather than herself. Okay, so then my next question is, why don't the proceeds from the actual sale of the house that were held in escrow. Why aren't they offset somewhere in all of this calculation?
I'm not sure why they would be offset. No one has that money at the moment. It was ordered into escrow to figure out who might be entitled to it. But the house was worth what it was worth, and the less.
Right, if the breach of contract damages are the value of the house as sold in 2019 minus the outstanding balance on the mortgage as it existed at the time of the first transfer, why doesn't at least the amount of the actual proceeds of the sale of the house get subtracted from those contract damages?
Because those proceeds haven't been paid over to the Makrises.
Well, do you agree that that it would be credited now if we were to affirm the judgment?
I think that what would happen at the trial court would be that those proceeds would be ordered paid as partial payment of the damages awarded, not as an offset of what the damages should be, though the end result is the same.
Well, it may not be the same with respect to the calculation of interest.
I think that, if I may answer your question, even though my time has expired,
Please.
I think that I'm still not sure why the setting aside of that money that hasn't been paid over should be used to say that the damage to the Makrises was less. The damage was what they expected out of the contract. The fact that money has been set aside to pay for it, I don't think I don't see how that would reduce the calculation of how much damage was done to them. And if there are no further questions from the panel, then I thank you for your time. I ask that you affirm the judgment of the Housing Court.
And we are back live and on the record.
The next case on our list for hearing is case number 2020 P623, Brian S. Hickey and another versus Pathways Association, Inc. and another. Attorney Parada, you may begin.
Thank you. May it please the court. I think what we have here is sort of a classic square peg, round hole situation. The land court's application of the zoning bylaws use table to ways and streets just doesn't work within the regulatory scheme. Hardly any municipalities in the Commonwealth expressly list ways and streets as allowed uses in their zoning bylaws allowed uses table. Now, the land court even recognized this problem or this sort of inherent conundrum, and that it actually ruled in the appellant's favor, in our favor, on the setback issue. And the land court said, well, setbacks at least don't apply to ways and streets. And in doing so, the land court sort of recognized, well, ways and streets are different than other parcels of land when it comes to zoning. And it just doesn't work to apply setbacks to them in those situations. And so setbacks don't apply. Our position, of course, is that the land court also should have decided that from a uses perspective, it's not necessarily for a local zoning bylaw to expressly list in its allowed uses table that a parcel of land or a piece of land can be used as a private way or street. When you look at this bylaw in particular, it even recognizes throughout the existence of private ways and streets in Venice, and that parcels of land and pieces of land may be used as private ways and streets. And those are listed in our brief. I think there's 6 or 7 locations where the bylaw talks about certain aspects of private ways or streets, even though private ways and streets aren't listed in the allowed uses table. So,
Attorney Parada, I have to admit, I'm having trouble understanding your argument because it seems as though I read the judge's decision to be saying not that the streets and ways themselves have to be identified in this schedule, but a structure on a premises has to be identified in this schedule. The
Well,
term premises is broad enough to encompass a private way, and therefore the structure has to be spelled out in the schedule.
Well, like most zoning bylaws, this one doesn't particularly list allowed structures. What it does is list allowed uses, and then to the extent a structure is put into place to advance those uses.
So the bylaw 2.2.1 says buildings or structures. I take it there's no dispute that this staircase would qualify as a structure. Is that right?
It would, as would a roadway and all sorts of other things.
Okay, so there's no dispute the structure shall be erected or used only as set forth, and premises shall be used only as set forth in the schedule. Any use not specifically enumerated shall be deemed to be prohibited. And
Right.
the judge found that the use of this staircase is not enumerated in the schedule. So what's wrong with that?
Well, that's not exactly what he found. What he found was the use of the land as a way is not allowed, and therefore the structure to promulgate is that is not allowed. There's no zoning bylaws that list a zoning bylaw that would list stairway or roadway. It's not really the way zoning works anywhere.
Well, but stairways and roadways are two different things. Let's pause for the moment. I'm having a little bit of trouble following your argument as you're responding to Judge Shin's question myself. Let's remove the question of any structure entirely, because you would still have a use of the way if people traversed a path on foot without any improvements whatsoever, right?
That's correct. Although the judge basically his ruling said that wouldn't be allowed because the use of a way is not listed in the allowed uses table. So, but I agree with your premise for the question.
Well, so your challenge to the judge's interpretation of the zoning bylaw, which was counter to the local board's interpretation of the bylaw, is that it produces an absurd result because by saying that the use is not permitted, quite apart from the question of classification as a structure, it effectively prohibits the use of a way. How do you get to that? How do you get to that conclusion? Let me start there because I want to make sure that we are on a solid footing, if you'll pardon me.
So the judge in his decision said in certain municipalities list private ways and streets as allowed. That's true, as we point out in our brief, but those are very few and far between.
Right. But I guess let me be more precise with my question, because it seemed to me that that essential to the judge's conclusion that this use was not allowed was the fact that the use depended on a structure. My understanding of the judge's application of the use table was that he used the use table, but then also the private clubs provision and the portion of the private clubs provision that dealt with the use of structures in the table of uses. And to go back to the question I asked you, if we did not have a structure here, I don't read the judge's decision as prohibiting the traversing of an otherwise unimproved private way.
Well, it might not prohibit the use, but it would prohibit any structure, including a roadway. And let me
so let's take this one step at a time. Sure. So now you say that it prohibits the use of a roadway, and I guess embedded, I'm assuming that embedded in that characterization, you're taking the position that pavement constitutes a structure.
Correct.
Can you point me to any setting where that conclusion has been adopted?
It's in the bylaw, and I actually can't reference the section, but it's in our, I believe it's a reply brief, and I'd be happy to follow up, but there's a section
that's okay. If it's in your reply brief, I missed it.
So a roadway, a structure, okay. or a drive, a structure. But I don't disagree that what the judge did was say that this structure as a private club would be disallowed.
Right, I understand
that was But the problem is even if that were, even if the ruling was upheld based on that, what my clients would do would ask to have the stairway be built on behalf of one easement holder. You would eliminate the private club issue.
Let me
What would
ask you
happen
a
then-
different question.
I'm sorry.
Assume that under the proposal that you made with respect to constructing this staircase, who would own the staircase?
So it would be the entity that's the appellant here called Pathways Association, Inc.
How would that be the case? How would title to that, ownership of that staircase, vest in the corporation?
Well, the corporation would put up the money to build it, and the
Okay,
corporation.
so they built it on an easement that's not exclusive, and they don't own the land upon which they have the easement. So can you explain to me as a legal proposition how the association would own the staircase?
Well, Post versus McHugh says that an easement holder has the right to improve it in order to use it, to use an easement. This court in the conservation case determined that Pathways as.
Who owns the land upon which the stairway is to be constructed?
So it would be the plaintiffs own part of it, and another entity called West Side Homeowners Association owns part of it, which is some of the same members as Pathways. And there's another lawsuit currently pending in the land court involving those parties. So when the easement holders as a group sort of bonded together to create this Pathways entity, they applied for various permits. That's what many of the other cases were about involving this way. In the conservation case, the court said that as the homeowners association representing the easement holders, they're a proper party to build and own the stairway. So that would, yes. Yes, they would own it. I mean, that's, as an easement holder, one owns and has the authority and an obligation to maintain a pathway or something like that.
That's to the exclusion of everyone else who has the same rights in the way.
Well, it wouldn't necessarily be. They would be allowed to use it as licensees potentially.
Be careful here, okay? Because the bylaw, it only prohibits a structure owned and or operated by a corporation or association of persons for social and recreational purposes. And I'm trying to figure out within those precise words whether you fall under ownership, and apparently you're claiming you do, although I don't 100% understand how. And then I was going to ask you about operation, but I'll accept for the moment that you're claiming ownership of the structure by virtue of the fact that you're going to pay for the construction of it. Although I confess I don't 100% understand how that can be as a legal proposition. Anyway, moving on. As proposed, is it the association's intention to restrict use of the stairway only to its members?
Well, it's unclear. The law is that if several parties have an easement over a piece of land and one easement holder improves it, the easement holder who improves it and sort of maintains the improvement, you know, and in most cases, you can't build multiple walkways or multiple stairways. So there's a body of law that suggests that in that case, another easement holder would have to be allowed to use it. The party owning it or who has built the improvement can charge a fee or something like that. But the point that I think the problem here is,
one of my issues is your arguments seem to me in some ways to plead yourself into the definition of the prohibited use. And I am puzzled by this as a strategic matter.
my understanding, you know, I don't see how we can impose ownership on other parties who aren't members of this association. You know, the association in the past has had insurance for use of it. So if your honor is familiar with a body of law that allows the easement holders en masse to own it in this situation, then certainly that would take it out of this decision or this definition. to some degree. But going back to that definition, the issue here is that even if one easement holder were to build this stairway, that issue would be gone, that private club issue.
Why wouldn't the judge's rationale apply to an individual easement holder? Because I read his decision to be saying, as a second ground, given the facts of this particular case, that there is an express prohibition in the bylaw for private clubs members only. But the first part of his decision is, even if there's not an express prohibition, if it's not specifically enumerated in the schedule, then it's prohibited. So why wouldn't an individual easement holder have the same problem?
They would, and that's our argument, that that's untenable in the way easements and things of that nature work, that where you have a private easement holder who wants to use a private way, be it to build a street, to build a street sign, to build a bridge, to build a culvert, in this case, to build a stairway, for the board to decide that that was reasonable, not arbitrary and capricious, given the tremendous amount of deference.
They'd only have the right to make reasonable repairs and improvements anyway. I mean, I don't see this decision to be at odds with that principle.
Well, the improvement is the stairway, because again, as we point out in our brief, every case, no one has ever disagreed in any of these cases that a stairway is necessary to use this way to get to the road to the beach. It's unsafe to use without a stairway. So what the board said was, well, sometimes what you need to safely use a way is a sidewalk. In this case, what you safely need to use it is a stairway. Everybody has agreed with that. Every lot along the shore has its own stairway. Other private ways that other entities use have their own stairways. It's tremendously unsafe and almost impossible to get over the armored bank from the road to the beach without a stairway. So when the zoning board said, well, it's reasonable here, they're not asking to build a road, they're asking to build a stairway. Yeah, everybody knows a stairway is what's needed to use this way for pedestrian access. And so that was totally reasonable, not arbitrary, capricious, and totally unreasonable, which is the standard. So in answering your question, that determination by the court that even an individual easement holder would be unable to build the stairway is in error, given that the zoning board has to decide how land may be used and what's reasonable or not. That the zoning board didn't allow a factory and apartment building to be built on the way. They allowed a stairway. The same way they may allow, in other instances, a road, a bridge, a culvert, or something like that.
Attorney Parada, thank you for your argument.
Okay, thank you.
Attorney Bowen.
Thank you, Your Honor. Good morning, and good morning, Attorney Parada. I'd like to start by pointing out that the SJC decision in 2015 was directed to what rights certain people have to use the way in question here. And that otherwise affirmed the underlying order by the Chief Justice at that time, Justice Shire in the Land Court. And it's interesting because her language in her order, which the SJC made clear it was affirming, is that the certificate holders, or the people with actual rights, can make the way passable by repair and the installation of steps. It doesn't say anything about staircase or stairway or this giant structure that Pathways was proposing.
But that does not have any bearing on the question that was before the zoning board, right? I mean, that was just a declaration of the conditions in the case that was before the court in that prior litigation.
Well, the bearing is that what was before the zoning board was justly denied and rejected by Judge Bay for two very important reasons. One is this group can't build anything at all on this way under the use schedule. And it can't be either for recreation or for this group, private group.
Is Attorney Parada correct when he says that interpretation would likewise outlaw all other existing roadways or stairways on private easement areas?
No. I mean, it applies to a private group, and that members language in the schedule, which I haven't in memory, but it's private club for members only. They can't build on this way. They can't put a road. They can't put anything in.
I understand your argument to be directed towards the nature of the organization, not to the nature of the structure. So I have a lot of questions for you.
Okay.
I did not understand, but perhaps you understand it differently. I did not understand Judge Vey to be ruling that no one at all set aside pathways, that no stairway could ever be built in this location as a matter of zoning, that's a prohibited use. Did you understand that to be the ruling?
We understood the ruling to be, number one, this group can't do it, and what gets built here can't be what was proposed.
Okay, but just because I read your brief and I thought what you were saying was that if it were just a stairway, that would be okay.
I think that is roughly correct. I mean, it depends on what the stairway itself is.
Tell me, as a matter of zoning law, why that more limited position is correct. Is it because the zoning law does not prohibit the erection of a structure that's necessary to make practical use of the way?
I think it's more in the context of this case, Your Honor. It's been up to the SJC, and it was already ruled on by Chief Justice Shire that they have the limited right to improve this way solely for the purpose of accessing the waters of Cape Cod Bay. They don't have the right
if that's
to.
A practical matter, you need to build a staircase for that, then that would be okay.
A staircase limited to that valid purpose, but what they proposed was vastly different.
So what difference does it make? I'm going to ask you a hypothetical.
Okay.
Let's take the following situation. Let's assume that in this residential zone district, a private homeowner decides to bequeath her home, which is a private residence, to this Pathways organization. And she dies and title passes to Pathways. And Pathways has no real use for this private home. So they just decide, okay, we'll rent it out. It will be like some form of revenue for our organization. And it gets used as it continues to be used as a private home. In every respect, it is used exactly as it was when it was owned by a private individual. Does that use become prohibited because of the change of ownership?
I actually hadn't thought of that hypothetical. I do not know, Your Honor. I do not know if that would mean that they would have to go in and get a variance.
Well, but can we agree that the use zoning regulations only control use, not who holds title?
Yes, we can agree on that. But
okay, so then again, what would be the answer to my hypothetical?
I think they would have to go get, if they wanted to use that as opposed to
as a private residence. What would be your legal authority for that?
I think it's in the zoning bylaw that says if it's not listed as an allowed use, I mean, as a private residence, it probably would be allowed. I mean, I don't think it could operate as a club.
Not my hypothetical expressly posited that it was used as a private residence.
And I think that would be allowed.
Right. I don't think I don't see any. Okay, that's enough. So then what relevance does, as a legal matter, does the ownership, the fact that this Pathways is, as I have a hard time understanding Judge Vey's opinion, frankly, because is he concluding that the structure is being used as a private club / members only structure, or is he concluding that the structure will be owned by a private club for members only? And if it's the latter, which is what I think he's doing, how is that ownership a prohibited use?
I think he's doing the former, Your Honor. And I
You
think
do.
that arises out of the definition of private club members only, which refers to both structure and use, which is an unusual wording, I thought, in the bylaw, but
I
that's how
didn't
the
see
bylaw
any
is written.
findings. I didn't see any findings in the opinion as to the use of this stairway as proposed that would support that theory other than the nature of the association itself. Can you point me to some findings that that showed that the structure itself would be used as a private club?
I think, I don't think those exact words appear in the ruling, but I think the whole import of the ruling is that the only entity that applied for to build this structure here was a private club, members only club, and that the use and the construction is included within that definition, and therefore it's barred because it's not included, it's expressly excluded from the schedule.
Yeah, I have to say here again, likewise, sometimes I get puzzled by why parties are making certain arguments because they seem to be, as a practical matter, contrary to their own self-interest. If the pathways made no restriction on who could use the stairway, none whatsoever, a consequence, by the way, that I assume your clients would think would be not great for them, but just said, okay, everybody who wants to come use, we've got this nice new staircase, come use it, no restrictions whatsoever. How could this staircase then be deemed a private club members only, simply by virtue of the fact that the organization had built it?
Well, first of all, as I understand that, Your Honor, Pathways, as Judge Vey did find, represents 35 of the approximately 200 owners that have easement rights. So if they said we let everybody in, I think as long as that structure is actually not anything more than what is expressly should be permitted by a variance, there has to be a variance in this case, because it's much more than just a pathway down the embankment to the waters of the Cape Cod Bay.
That's a separate argument. But what I hear you saying is that if they opened it up to everyone to use it, then it couldn't really be considered a structure for a members only private club structure.
I'm not saying that, Your Honor, because I don't actually understand how that works. I don't see how the title or the holder, as you were asking, who's going to own, the actual structure that does get built, and how they control it, who's going to, pay taxes on it, I guess, if there's any taxes involved. If that is a private club members only, I don't know how they get around that. I think it has to be,
because zoning regulates use, it doesn't regulate ownership, I think is the point that Judge Wolohojian is making.
well, I don't know how we read that that language in the schedule that excludes.
Well, but the point is that the language may say that, but under Chapter 40A, it may not be enforced to the extent that it purports to regulate ownership rather than use. That's, I think, what I hear.
Right, and there are no findings, as I saw it in the judge's opinion, other than ownership.
I'm not sure.
Or not even ownership, because I don't think that there are any findings pertaining to ownership. I think he's just making a finding concerning who's planning to build the staircase.
Well, he also did make a finding, as I just mentioned, that Pathways represents, it doesn't have ownership, it's not a title issue. It represents only a fraction of those who have this easement right to use the property. They have a property.
Let's also then go on to the next foundational reality here, which is that Pathways does not have the legal authority to prohibit persons who have easement rights who are not members of its organization from using the stairway.
Correct.
So by definition, the use of this structure is not limited to members of pathways. That formulation itself runs into exactly the same kind of jumble that we find when we start intermingling ownership and use.
Yes. Attorney Parada said that they would bring in one easement holder. It would go apply for the permit, and under section 1.3.1 of the bylaw, it would have to be examined. And we would think that if they propose the same thing with these enlarged, widened landing areas that invite and encourage, as Judge Fay found, people to loiter and linger and cause problems, then they would need a variance.
Can I
And
ask
I would think they would need a variance anyway.
Can I ask you, Attorney Bowen, if there was no express prohibition for private clubs members only in this schedule,
Yeah.
would your argument be that the use regulations apply or they don't apply?
The use regulations apply as modified or as defined by the SJC and by Judge Shire's opinion, that it has to be installation of steps that enable use of the easement, period. And that easement has been decided in other cases.
That's a question regarding the scope and rights in the easement itself, not about the zoning question. When there may be, I'm sad to speculate, follow-on litigation about whether this exceeds the scope of the rights that the Judge Shire determined, even if it's permissible under zoning. But for our purposes today, this panel of 3 appeals court judges is going to have to wrestle with the narrow question of the zoning, the application of the zoning bylaw, and Judge Vay's treatment of the board's decision.
Well, we do have a ruling from Judge Fay that was issued on the same day as this case in 16 MISC 00.
That's a different case, and that's not right. I can assure you that we're not going to be deciding that.
I don't understand your answer to my question. Okay, so all the facts are the same. This is the staircase that Pathways wants to build, except there's no express prohibition in the schedule for private clubs members only. Would they need to seek a variance, or does this use restriction not apply? Because I thought you were arguing that even without that express prohibition, that the last sentence of section 2.2.1 would still require them to get a variance.
Yes, that's what I'm arguing.
Okay.
And is that because staircases aren't allowed?
That's because it's a permit that has to be issued for the construction of something pursuant to 1.3.1. Whatever they construct, whatever construction or structure, whatever size or shape they put in that easement area, as required by 1.3.1, must be conform to all aspects and provisions of the zoning bylaw. That was the first thing that we appealed to the zoning board from the building inspector's ruling. On 1.3.1 is very broad. You can't put any structure.
An individual easement holder wants to build stairs. That I assume stairs qualifies as a structure.
Yes.
So then why would this use restriction also apply to them if they just wanted to build a simple set of stairs?
It would. They would have to get a building permit from the building commissioner inspector. It says it right in 1.3.1. He's the person charged with issuing permit, and he has to make sure it conforms with all the provisions of the bylaw, which is it, and the only thing that Judge Fay definitively ruled did not apply from the bylaw is the setback provisions in the way. But the other provisions of the zoning bylaw do apply.
Just so I can be clear, I want to understand your answer to Judge Shin's question, because I understand that as a structure, it would have to get a permit and it would have to conform to the provisions of the bylaw. If an individual easement holder wants to build a staircase, which provision of the bylaw do you say that staircase would violate? Taking out the private clubs.
I beg your pardon? I'm sorry.
Excluding the private club section.
I don't know the answer to that off the top of my head, John. I apologize. I wish I had more time to dig through and find that.
It's
but
that it's not specifically enumerated in the schedule. That's what you're arguing, right? It's
Right,
like it's like the basketball court case.
Right. Yeah, and it's not in there, so there has to be some kind of, because it's not in there, it has to be a variance. And then we have to go to the procedures of 48 section 10, which would give us the right to ask for safeguards and limitations.
And that same analysis would apply to every paved street constructed on a private way and every other boardwalk or staircase constructed on any other easement area in the town of Dennis.
If it falls within that last sentence of section 2.2.1, yes. If it's
Okay.
not specifically enumerated.
I think we'll have to leave it there. Thank you.
And we are back live and on the record.
We have reached the sixth and final case on our hearing list today, case number 2020 P200, ERIN E. Wynn and another versus Baystate Mary Lane Hospital and others. Mr. Anguera, you may begin.
Good afternoon, members of the court. David Anguera for the plaintiff appellant in this case. This case involves an issue where we allege an abuse of discretion by the judge, improper cross-examination by defense counsel, and improper closing. But I think the procedural chronology, which I know the court is familiar with, is critical to understanding what happened in this case.
Well, before you get too far into the procedural chronology, I do have a question about procedure, and it goes to the jurisdiction. As I read the docket, there was judgment. There was a motion for a new trial that was filed some 22 days after the entry of the judgment. But the notice of appeal was not filed for quite some time later. How is the notice of appeal timely in this case?
Well, we had filed two notices of appeal, is my recollection. We filed a notice of appeal prior to the motion for the new trial being decided. We then filed a motion for the new trial, which was delayed for about 1 year. And then after the denial of the motion for the new trial, there was another notice of appeal filed. So we filed two of them. So I think the matter is properly before the court. And my recollection is that the defense never raised that issue. So I think
I understand that, but I guess I'm looking at the docket. The very first notice and the only notice of appeal that I see on the docket was filed on December 19th of 2019. I don't see on the docket and any notice of appeal that was filed after the original judgment or before the motion for new trial.
I'd have to have a few moments to find that, Judge.
Sure.
May I defer the answer to that question?
Of course. Of course. I don't see it on the docket.
Understood, Your Honor. I understood the issues.
I see in the record.
Not been raised by the defendant in this matter, and there was a motion for a new trial that was fully argued. You have the transcript of it, but if I may continue and find the correct answer for you about the docket. But the reason I talk about the procedural chronology is because of the issues of the two medical reports, the 2013 and 2018 medical reports, and that becomes a relevant issue with respect to the cross-examination of Dr. Dexter. Keep in mind, Your Honors, that in 2013, when the first report was prepared by Dr. Dexter, there was no complaint filed in this case at all. And I know that you're familiar with the Medical Malpractice Tribunal statute, and what we as Plaintiffs' Counsel do is to have our experts prepare reports in anticipation of the tribunal so that we're properly prepared to present that evidence. In this case, the complaint was actually filed against Dr. Sanji, the cardiologist, only in 2014. So the 2013 report that defense counsel used to cross-examine was a report specifically prepared for and only prepared for the tribunal. There wasn't the expert disclosure. And of course, Dr. Dexter, who's a cardiologist, cannot testify as to the standard of care of a hospitalist. Now, having said that, in 2016, the complaint was amended to add another defendant. That was Dr. Octaviani, the current appellee. And then in 2017, the complaint was amended again to add Dr. Rosenfeld, the internist involved in this case. The reason that that's relevant is because with each of those additional defendants, there were additional expert reports prepared, submitted to the tribunal, with properly competent and qualified experts to deal with each of those issues, as was required under the statute. And that's exactly what we did. Now, what changes here, and as experienced lawyers know, when you get ready for a trial, there's a lot of work that needs to be done. But one of the most important things that we have to do is to prepare expert disclosures. And we knew this case was going to be tried in October 2018. We were told that the case would be assigned to Judge Flannery. We learned at the time, and this is not a criticism, just an observation, Judge Flannery had just been appointed to the bench, I think 1 or 2 months before that. We learned that he had only been a criminal defense lawyer and had never handled a civil trial at all. I'm only saying that in terms of trying to understand the complexity of my trying to explain these complex legal medical issues to Judge Flannery. And he admitted that in his own transcript, that he said, "Excuse my ignorance in this case," and that's what he was referring to. But having said that, in 2018, days before the trial begins, one of the defendant's insurance companies approached us and said, "We want to settle the case." Great, terrific. Within days after that, the second defendant approaches us and says, "We're going to settle the case." So now, instead of presenting expert disclosures and an evidence, a trial strategy, essentially saying that this is joint and several liability among all three defendants, each of whom could be independently and or collectively responsible for the harm, which is what the law allows, we had to change the entire strategy of the case. And with that, we felt an obligation to provide to the court new expert disclosures. That's exactly what we did in 2018. Now, in that expert disclosure, which
continue to use the same expert.
It was, we decided to use Dr. Janai, who is a hospitalist, to testify about standard of care as Dr. Viana.
But you also decided to use the same expert that you had used earlier with respect to the cardiology opinion, correct?
Correct. Only with
You
respect.
You didn't have to do that.
No, I did not.
You could have gotten an expert who didn't carry the same baggage of having had a previous opinion about the case that ascribed liability solely to the cardiologist.
We certainly could have done that, but we didn't see the need to do that because
once you do make that strategic decision to use the expert who carries a history with him, he carries a history of having offered previous opinions about the same facts, different defendant, but the same facts and the same medical situation. I mean, why is it that what insulates that expert from cross-examination about his previous opinions?
there are two reasons that opinion should be insulated. Number one, when we filed the motion in limine, this issue came up, and I argued to the judge that the defendant's motion in limine was trying to strike the testimony of Dr. Dexter relevant to Dr. Actaviani. And I agreed with that. If you look at the transcript, I agreed with that and said, they are correct. That was inadvertently put in that Dr. Dexter would talk about the standard of care as it relates to Dr. Actaviani because he's not a hospitalist. He's not qualified or competent to testify. The defendant acquiesced in my statement and accepted it. It's right in the transcript. And they said they understand plaintiff's representation. Therefore, that's a moot issue. So as I proceeded with this case, I understood that the issue of Dr. Dexter's expert disclosure, where he originally inadvertently wanted to criticize Dr. Actaviani, was no longer an issue. The 2013 report was only against Dr. Sanji, who as a co-defendant could be responsible in joint and several liability based on his breach of the standard of care for contributing to cause harm, not the so-called.
I mean, to cut to the chase here, disregarding the fact that you settled with the other two people, if you had put Dexter on the stand and he had offered an opinion previously against someone, one of the other caregivers, that said the fault lies with that caregiver, why can't that person be cross-examined on that topic?
Because his opinion on the fault goes to liability. Liability is specifically prohibited under 408 for purposes of the settlement, because in order for me to rehabilitate Dr.
I'm not talking about a settlement.
I understand.
And also, the cases you rely on, Maria and Zuko, I don't read them the way that you read them. And notably, in both cases, the challenged evidence came in because it wasn't confined solely to the fact of settlement. And here, the fact of settlement was not the subject of the cross-examination of these defendants.
But Maria, that's the defendant's argument that Maria is only to settlement, and it does not. It adopted Rule 408, which specifically prohibits evidence of conduct made during compromise negotiations about the claim. The conduct in this case is that the plaintiff settled the case on the eve of trial. So in order for me to rehabilitate—
But the opinion was not generated. Dexter's opinion was not generated as a part of settlement negotiations, was it? It preceded that by a long shot.
It did, but what they were trying to do by cross-examining him, by asking him where in this report, in either 2013 or 2018, do you find something that Dr. Octaviani did wrong? Number one, he's not qualified to comment on that because he's not a hospitalist.
But it doesn't matter. He's certainly qualified to comment on what is and is not in his previous disclosures.
I respectfully disagree that an expert can
expert can be cross-examined all the time, can he not, about what he didn't do? You list two sources, you list two treatises, Mr. Expert, in your report, but you don't list this treatise here, that treatise there, this third treatise over here.
That's completely different, Your Honor, from the cross-examination of an expert who's not qualified to comment on the standard of care of a hospitalist. He simply isn't qualified, and there's no prior inconsistent statement here. The statement contained in 2013 simply says that I find, in my opinion, that Dr. Sanji violated the standard of care and contributed to cause the death of Mr. Baglio. I didn't oppose that. What I oppose is that they're using it to try to impeach him with a prior inconsistent statement, which is not an inconsistent statement with his opinion, saying that the cause of death of Mr. Baglio was his cardiology condition. So there is no inconsistency there. And that's what I tried to—
You were able to bring that up. You were all able to bring all of those points up on redirect.
Well, if you saw my redirect, and this is where the dilemma comes in as trial counsel, the judge finally threw his hands up and said, well, the cat's out of the bag at this point, because he realized that now issues that should not have been presented were presented because of the improper cross-examination by defense counsel. So now he basically says, I'm going to let you ask follow-up questions. What do I ask Dr. Dexter? Is the reason why you don't have an opinion in 2018 about Dr. Octaviani because the case had settled before? That matter was resolved with Dr. Sanji? Or do I recall the plaintiff, the widow in this case, and say, can you explain to the jury what happened in terms of Dr. Sanji's case and the insurance case? There's no way to properly rehabilitate the witness.
You can ask questions that say, for example, were you asked to examine the liability or the contribution of Dr. Octaviani back in 2013? And he would say, no, I was only asked to look at Dr. Sanji, and that's all I did.
I did ask that question, Your Honor. If you look at the transcript carefully—
And why isn't that sufficient rehabilitation?
Because it's not sufficient, because it leaves speculation on the part of the jury. And look at the closing argument of defense counsel, where they said they were attacking the credibility of Dr. Dexter and said that you can infer from the fact that Dr. Dexter did not comment on the liability of Dr. Octaviani, whether or not he's credible. And that goes directly to the heart of my expert's testimony. So they're basically attacking Dr. Dexter because he didn't comment in 2013 on the liability of a defendant, which he's not competent or qualified to testify about, in 2013 when the case hadn't even been filed. And again, keeping in mind that the defendant agreed and understood in the motion in limine that we were withdrawing the inadvertent comment that was in that report, and that Dexter was limited to only causation. So there is no inconsistency. The law allows joint and several liability against defendants. If all three defendants were in this case at the same time, it's a different case. But what happens in all these cases from this day forward and has been happening is if you have multiple defendants and you have different expert disclosures, if a witness is incompetent or qualified to testify about a standard of care, it doesn't matter. That goes to the weight of the evidence. But in this particular case, the cross-examination was improper because of that and because it violates 408B. I'm sorry, A2, which talks about the conduct. So there was no way for me to effectively rehabilitate Dr. Dexter, and I did what I could. Now, that what makes this situation even more problematic is not only was the cross-examination improper, and despite counsel's representation to the court that they were not going to ask questions on liability, they did. Then they argue it on the closing statement. And that's when I went up after the closing statement. I objected and stated to the court, Your Honor, at this point in time, based on your rulings and what has happened in this case, there is no fix for this problem. There's nothing that I can do to fix this problem, rehabilitate it. They attacked Dr. Dexter, basically saying that the jury can now infer from this statement that they claim is inconsistent with his prior statement, but there is no inconsistency. I see my time has expired. I have a lot of other issues to discuss, but unfortunately my time has run out. I apologize.
Well, we have your brief on that. I would ask you, I went back and looked at your brief on the statement of the case, and I see only one notice of appeal reference there as well, and it's the one that appears on the docket. So I would encourage you, if you have something to identify that the docket is incorrect and that there was a notice of appeal filed, please bring that to our attention because it goes.
We will do that. We will do that immediately, of course.
Okay. For the defense.
Yes, may it please the court. 3 issues before you. The propriety of the cross-examination of Dr. Dexter, certain comments made by defense counsel during closing, and the sufficiency of the evidence. We submit, as we briefed, there were no error as to the examination or comments at closing, and there was more than ample evidence to support this verdict, which was rendered after 2 weeks of trial. As to the cross-examination of the plaintiff's trial expert, the claim that's being made is that it violated the rule in Morea that there cannot be any introduction or mention of the settlement. 2 issues there. Number 1, it was not adequately preserved, and 2, there was no error. As to the preservation, the issue of the admissibility of any settlements with Dr. Sanvi and Dr. Rosenfeld was brought up by a motion in limine, and that was discussed and ruled upon. When the examination comes, and the claim now on appeal is complaint about the cross-examination, no objection was ever made saying that the cross-examination was transgressing Morea. Motions in limine do not secure the right. You have to make sure you bring up your specific objection at the time of trial, and that was not done. Number 2, as to the merits of that, the cross-examination, I think what the plaintiff is trying to argue is that the cross-examination of Dexter as to his expert disclosures was the equivalent of relying or introducing on the settlements. There's no case that stands for such a proposition. The fact of pre-trial settlements does not insulate an expert from being examined as to his disclosures, which he carries with him throughout the case. It was reasonable to expect that Dr. Dexter, who reviewed this case, would identify any criticisms he had for any of these care providers. Now, as to the specific examination where these disclosures came up, they were relevant and material for 2 reasons. Number 1, the reliance defense, which was predominant throughout. That is, Dr. Octavani defense, which overlapped both standard of care and causation, was that he had the right to rely on Dr. Sanvi, the cardiologist who did the workup, the specialist on this cardiac-related presentation. That was from the get-go. And number 2, it was relevant, that is the reference to the disclosures to credibility. Now, as to reliance, the absence of any mention of Dr. Octavani in those prior disclosures, complete absence of any mention, either critical or as to a causative role, was consistent with the defense that he had a right to rely on that recommendation. And number 2, what's missing from the plaintiff's briefing, and I'll ask you to take a look at that examination, the direct, the cross, the redirect and the recross, and you'll find two things. As much as he's saying that Dr. Dechter was limited to causation, he wasn't. If you look at the questions that he asked in direct, they cast aspersions on Dr. Octavani. There wasn't any penultimate question as, doctor, do you have an opinion as to whether Dr. Octavani deviated from the standard of care? But there was plenty testimony that he was critical. And I'll make some references. It's in Record Appendix 3. When someone's suspected with coronary artery disease, you ask very specific questions. Well-known coronary artery disease causes heart failure. Plaintiff had risk factors for coronary artery disease. And then on redirect, can't rely on information that is obviously inconclusive. Dr. Octavani was the last person to see the plaintiff before discharge. Dr. Octavani was the last person to write a note before discharge. Dr. Octavani had no memory of speaking with the plaintiff. Dr. Octavani put non-cardiac pain in his discharge report when no one ever told him that. That is suggestive of criticisms of Dr. Octavani. And in addition to that, those criticisms, both on direct and redirect, there was the penultimate causation question, which is at 813. And that was coronary artery disease would have been diagnosed if they had done a nuclear test. And then, as you'll see on initial questions by defense counsel, he had Dr. Dechter admit that if a nuclear study had been done by Dr. Octavani, further interventions would have taken place and everything would have been all right. He was attributing causal responsibility to Dr. Octavani. He was attributing criticisms to Dr. Octavani. And so it was well within the right of cross-examination to point out that in 2 of his 3 prior reports, he made no mention of Dr. Octavani, and it did go to his credibility. I would say that there's been reference to lack of competency. Again, I would suggest that that fails for 2 reasons. First, it was also not preserved. There's not one objection in the course of the cross-examination which ever raised to the trial judge's attention that Dr. Octavani was not competent to testify as to anything in his cross-examination. Not once. As to the evidence itself, excuse me, Dr. Dechter, I apologize, Your Honor. Not one objection that he was not competent to testify as to anything that he did on cross-examination. Also, as has been mentioned a few minutes ago, Dr. Dechter was specifically designated to testify as to standard of care and causation as to Dr. Octavani. It was done a week before trial. The fact that the plaintiff later says that, well, that was inadvertent and it wasn't going to pursue it, the fact that he signed a disclosure, I would suggest, precludes any argument now that he was not competent. And then look at the record. Board certified in internal medicine, training and practices in the hospital setting, clinical professor for over 30 years and does his teaching all in the hospital based. He was more than qualified to testify on the issues that were raised in cross-examination. And one of the things that really jumps out or should jump out is that when he makes this argument about lack of competency, there's nowhere where he really identifies any topic that was raised in cross that he wasn't competent about. Let's take the reliance. That was brought up. He was questioned about the right of a hospitalist to rely on a cardiologist. Dr. Dechter really had no issue with that principle and would be more than competent to testify about that. The second aspect, which appears to be what they're complaining about, is that when it was raised about his discharge report, that he wasn't competent to talk about the discharge report. And he, in fact, tried to say, well, I'm not being critical. But if you look at that exam, defense counsel was get the admission, and Dr. Dechter agreed that because it was he said non-cardiac in that discharge, it left a false impression. And then the cross goes to his disclosures. you look at the disclosures, and all defense counsel did was elicit that nowhere in those disclosures did he ever issue a criticism about that discharge report. Perfectly appropriate cross-examination and directly responsive to what Decter testified to. And there's no basis to any way suggest that he was not competent. There's been reference in the briefing about the closing argument and reference to sidebar. Those issues I would suggest are insufficient for any finding of a reversal here. The reference to the sidebar was a very fleeting reference. It was defense counsel pointing out that when he was recounting some of the testimony from Dr. Decter that there was a sidebar. And during that time, Dr. Decter had time to review his disclosure and then later confirm that it didn't contain criticism of Dr. Octavani. There was no mention of any substance of the sidebar. There was no mention of anything that went on during that time. And the judge, out of an abundance of caution, went ahead and gave a curative instruction. So to suggest that the sidebar somehow prejudiced this case is without merit. They also argue that in the closing that defense counsel referenced that the Dr. Decter was a causation witness when defense counsel should have known that he examined on the standard of care. Well, referring to Dr. Decter as a causation witness was accurate. He was primarily called as a causation witness, but as I've explained and as you'll see from the record, he did leak out criticisms through plaintiff's questions as to Dr. Octavani, and he was questioned appropriately. And cross-examination, I would add, is not limited to direct. And just because an expert is said to be only on causation doesn't prevent exploration on cross as to whether he's got opinions on the standard of care. So the bottom line of the closing was it was accurately represented as to what Dr. Decter had testified to. And as we also know, the instructions made clear and the jury understood that closing arguments are not evidence. The jury otherwise was given very appropriate instructions where there was no objection, saying that they are to, there can be more than one cause, there can be more than one responsible person, and that they are to focus on Dr. Octavani. So I suggest that there was no error and certainly no material prejudicial error. And then lastly, as to the claim that there wasn't sufficient evidence, there was more than sufficient evidence to support this verdict. Dr. Octavani defended his care in all respects. He had the support of a well-credentialed hospitalist, Dr. Lee. The issue they raise apparently is that they believe that there was an issue of whether he had chest pain at the time of discharge. That was disputed. And I will note that I didn't in my briefing, plaintiff's counsel has issues with me not citing to the record enough in my argument section, and I probably should have done a better job, but everything that I cited or mentioned in my argument section on the sufficiency of the evidence is in my factual section. But as to pain, one reference I didn't make, I'll make it to you now, is record appendix 4 at 78 is the nursing notes that indicate there was no pain, no chest pain at the time of discharge, but headache pain. Otherwise, there was evidence that he was in good condition and improved. And it was also evidence, despite the plaintiff saying that Dr. Octavani didn't do a physical exam, there wasn't a testimony and evidence that he did do a focused exam that was part of his custom and practice. Bottom line, the evidence was more than sufficient. It wasn't the basis of any bias, wasn't the basis of any prejudice or misapprehension. This jury understood this case and rendered its verdict after 2 weeks of trial. I guess if there's not any questions, I would basically leave my remaining arguments to the brief. As to Chief Justice Green, if you would like, I'm a little sheepish on the jurisdiction question. I have a note that a notice of appeal was filed within 30 days of the decision on the motion for new trial, but I don't know about the judgment. I'll be glad to send a supplemental letter just so the court has the advocate's position on that.
Well, maybe in my view, if I may, sorry, I was going to say, this doesn't seem to me that it should be a question of advocacy, that if the two of you conferred and were able to confirm that, you know, that the docket is correct. If someone's going to argue that the docket is incorrect, then that person should probably get in touch with us with whatever support they have for that.
No, Judge, that makes perfect sense, and I'll work with David, so we'll get you clarification of that.
Well, Attorney Wiegand, I had a question about that. When you filed your opposition to the motion for new trial, did you make any argument that it was untimely or procedurally raising arguments that were procedurally improper? Or was the opposition based solely on the merits of the issues?
I wasn't counsel then. My best memory in preparing for this is that there was no mention of any jurisdictional untimeliness argument.
Okay, so let's just assume that there was not an original notice of appeal from the judgment. And there should have been, because let's say some of the issues raised in the new trial motion should have been raised on an appeal from the judgment. But has that now been waived and it takes us out of any sort of jurisdictional problem?
The only, and I wish I knew a better answer to this, Judge. It's a good question. I don't know whether if that is a failing, that goes to the subject matter, which is never waivable as far as appellate matters. So that was only why I made reference earlier to having any advocate position as to waiver. But I fully recognize that my memory is that was not raised in the opposition for the motion to trial.
Okay.
Thank you. Thank you all. That concludes the argument in this case. This case is submitted. It also concludes our session.